Highly rated defence attorney Ulrich Roux joins us over Skype from Johannesburg this afternoon. Ulrich followed today's events at the North Gauteng High Court in the sentencing of Oscar Pistorius and gives us his interpretation of events. Ulrich, thank you very much for joining us this afternoon. The state and the defence offered very differing versions of Oscar Pistorius today, one of a psychologically broken man and one of a man who's still very much in charge and partial to aggressive outbursts. What did you take from today's proceedings?
Yes, I think we could always have expected the defense to call a psychologist to come and testify about the psychological and emotional well-being of Oscar Pistorius. Of course, referring to the period of imprisonment that he's already served, the effect that has had on him, and his mental well-being and state of mind going forward. The argument that the defense has put forward is that it will not be in the interest of justice for Pistorius to go back to prison. He's as they call it, a broken person, and that the interest of justice should be that he gets rehabilitated under, for example, house arrest than to go back to prison. I think one of the most important things that came out of the testimony today is that the psychologist who testified, said that Pistorius will not be testifying himself because he cannot endure the cross-examination that Harry Nell will pose to him. And I think that's a very important point. I've always been of the opinion that should he adequately want to convince the court to be lenient towards him and to show to the court that he is, one, remorseful for his actions, and two, that he accepts responsibility for his actions, then he should have testified personally and testified himself and tried to convince the court of these facts. Now, today we heard he's not going to do that, and I do think that's going to, the court will make an adverse finding regarding that.
Now, the psychologist, Prof. Jonathan Schultz, obviously testifying for the defense and saying that Oscar's condition has certainly deteriorated over the past 2 years, and sort of diagnosing him with some pretty serious conditions such as major depressive disorder, post-traumatic stress syndrome, social phobia, agoraphobia, panic disorder. What did you make of that?
Well, I think definitely, it was evident during the course of the trial as well that he suffered from general anxiety. He was sent for psychological assessment in terms of Section 78 of our Act. And I think it is common cause that he definitely, psychologically and emotionally, is not the man that he was before this incident took place. And I think, to an extent, it could work in the defense's favor, that they will try and prove to the court that nothing will break this man even further. He's gone through the depths of hell. His international athletics career is done. He will never be accepted back into society. Emotionally, psychologically, he has suffered severe damage throughout this ordeal, and that a prison sentence will just doom him, even more. And obviously, trying to use those factors and the fact that he has been so emotionally broken down as a point that they want to use in mitigation of sentence to try and convince the court not to send him back to prison.
In your experience, Ulrich, I'm not sure if there's much precedent for this. It's obviously a very unique case, but if sending him back to prison is not constructive, what are the sort of alternatives then? Obviously, there has been suggestions that he could give back to society. He's been offered a job. He could do community work. Do you agree that would be the sort of best solution, the alternative solution?
Well, I think that one must look at, the start of the case, and obviously he was initially convicted of culpable homicides, in other words, the negligent killing of another person. And I think that the sentence which was handed down for culpable homicide by Judge Masipa was correct. It was the right sentence for that crime. Obviously, the appeal court overturned that conviction and has convicted him of murder. But remember that it's murder dolus eventualis. In other words, murder with indirect intent to kill a person. And, the important factor that we need to consider is that the court did not find that he acted either with hatred, malice, vengeance, predetermined acts, all of that. The court found that he did not act with any of that, and that he actually just had indirect intention when he killed Reeva Steenkamp. And the important fact is that so the facts have not changed. And that is why there's a large school of thought, and also his defense team saying that, he was initially sentenced to 6 years, 5 years under house arrest, and that should still remain a suitable sentence because murder dolus eventualis. And the indirect intent that he had to kill the person is not that far off from culpable homicide. Now, whether they'll be able to convict that in fact true in law, we will have to wait and see. Because remember that a murder conviction in South Africa carries a minimum sentence of 15 years imprisonment, and he will have to show substantial and compelling circumstances to the court if he wants the court to deviate from this minimum sentence. Now, I do not foresee him receiving 15 years imprisonment. He's of course already served 1 year imprisonment and almost a year under house arrest. Other factors which will also be considered is, of course, his disability and the fact that he could still contribute positively towards society. Whether the general public and the state will see that as a sentence which is possibly too light at the end of the day, I think we can take, definitely confirm that. But she will have to strike the balance between the interests of the accused person, because believe it or not, he does have rights, and he also is entitled to a fair trial, as well as the interests of society and what message is sent out to society. Remember that an innocent person lost her life during this entire ordeal, and the court must take it upon itself to send out correct message to prevent this from happening in future. So certainly a very difficult task that the court has to strike that balance and to find an appropriate sentence.